To call the public hearing to order, and I believe you represent Stony Brook?
Yes, sir.
So we had a site walk, very informative. Got to look at the lay of the land.
So again, we're here for hopefully preliminary and final approval for our 6 dwelling unit subdivision located off Route 11. As you mentioned, we had the site walk there Sunday. We showed you the layout of our private roads. We'll have access for all the existing units as well as the 2 proposed. We walked the property. You can clearly see that it's a pretty benign layout, and per suggestion of the board, with the plan, we have included a right-of-way for future access to Mr. Douglas's land, which he owns a separate entity in the back, so that he has some connectivity rather than Carbonell Road in the future. As I mentioned, this is simple. Duplex, duplex, duplex. The ones in orange are proposed. We have septic system designed for the back. Wells will be in the front. This blue area here is to handle stormwater, which will come from this portion of the road will roll back. This portion rolls back this way and goes into the wetland further off site. This will address stormwater needs for the development as well as a portion of the road. Because of the alignment of the road and needing to have a setback from the existing, the driveway has to shift over. Mr. Douglas is prepared to relocate culverts and things like that. We do have an entrance permit from MDOT for that shift, and this will be gravel with a hammerhead turnaround, and each duplex will have an area for parking as well as access into the structure. We feel it's pretty simple design, and I think you start to feel that it makes sense. So we're here to see you for any questions and whatever discussion you might have.
So, unfortunately, when you talk, you raise questions in my mind.
Oh, shoot. Don't do that.
What just triggered me was you saying the runoff on the left there, the lower left, was going to go, that's onto his property.
Correct. That's all his property.
So he's responsible for the runoff if it's on his land?
Right. Yep. We took care of this because this did come towards Route 11. Yep. This is an infiltration, so that'll infiltrate. This is all very good type A sandy soil through here, so that'll infiltrate prior to reaching Route 11. And again, where he's renting these, he will have full control and maintain the road under himself. There's no association.
Mariella, do you have anything?
I do.
Question. What are you going to do with that existing property?
That will be grass reseeded. Yep. Oh, and one other thing is, I know we discussed this earlier, but the point here, all the way down to where it intersects with Carbonell, there's an existing home here. This will be retained and moved properly.
Is that in the notes?
I believe it's in our description, but clearly it'll be on the final plan.
That's what I'm interested in.
Yes. Yep.
Okay.
No, right here.
Okay. Good. Thank you. Does anybody have any questions about this?
I'm just curious. So he's going to retain ownership over the property and the house and the dwelling unit?
Yes, he's renting them, so he'll have ownership of those.
What happens if someday he wants to sell them? I don't know the answer. Like, I'm not asking the question, but the answer. Like, what happens if someday he wants to sell them and separate out the properties? Is that, I'm not saying he does.
Yeah.
What happens?
That could be challenging because of the configuration of the land. The only thing he might be able to do in the future, which might make sense, is to condominiumize these, to make this into a condominium project versus a rental project. Simply there, you have to create a condominium plat where it would be basically the ownership would be of the structure and everything else would be limited or common elements that everybody would have access and rights to, but there'd have to be a condominium association established. A little more foot-leg work to do, but not impossible, but I don't believe that's in his interest at all to do it.
Is that state law or is that our ordinance? Right?
The condominium?
Yeah.
State.
Cluster zoning be possible there, maybe,
I don't know how much he owns.
Yeah, he owns many, many acres back here, so I think he could transfer land to himself if he needs to. He's got it in two different entities, but he can clearly transfer land to himself if he needs to. I believe that under condominium law too, that, there has to be a condominium plat, and I'm not sure whether this board has to sign it, but I do know it has to be recorded in the registry. But I believe it's very similar to a rental situation, other than one owner, you could have 6 unit owners. All the same provisions, and the same subdivision standards you apply to each one of those owners.
Do you have a number for the units, parking spaces per unit?
We applied, 4 parking spaces for each duplex, so 2 per unit.
Okay.
Anybody else have anything to say here? You okay?
I'm okay, if you're okay.
Okay. So I will, unless somebody follows up, I will close the public hearing, and we will continue. We're not going directly to you. We got a couple of little things to take care of. Okay. So I call the meeting to order. We've got 1, 2, 3, 4, 5, 6 members present, and so Mike Allen, I'll ask you not to vote. Okay, everybody else is a voting member tonight. 5 members being what we need for voting. Consider the minutes of the previous meeting. Did you all receive them by email?
Yes.
And did anybody like them? Who wants to say, I move we approve, for instance?
I move we approve the minutes of the meeting as written.
All right, and I'll second that motion.
Anybody want to comment? All those in favor? Okay. Thank you very much, Don. Appreciate your work. John, I hope this is quick and easy, and that's why I put you up front, so that you don't have to sit here the whole time. So, if I may state it briefly, and you correct me if I'm wrong, John wants to put up a sign for his business. His business is a home office, a home occupation, so he doesn't need a conditional use permit for that. His the company that you franchise for or work for?
It is my own company. We're in the process of obtaining a dealer developer license for manufacturing homes.
So the dealer that you would represent is requiring you to have a sign.
The state is requiring you to have a sign.
The state is requiring.
I'm not really sure why. They're looking at it, you know, the one size fits all type thing. They're looking at it like I would have retail space, like I would have home homes there, but that's not what's going to happen. This is just going to be headquarters, buying lots, clearing them, putting the homes on them. This license allows me directly with the manufacturer rather than a retailer in the state to keep my costs low so that I can transfer those savings.
So the requirement to be a dealer, you have to have a sign. And you don't want it out front?
I don't, but I don't know what this. Ideally, I want it on the back of my house where my rear entrance is, so that my house looks like it's a residential place. If they require it to be out front, then maybe I have to have a different conversation with you. I don't know those specifics just yet. I know I'm required to have something.
Have they specified how big the sign has to be?
I think that has to be, I think that's determining, you determine what the size has to be, and they're going to have to accept it. We can't break.
So we have no sign ordinance involvement. But when somebody gets a conditional use permit, because usually they're going to have a business, so they need a conditional use permit, we have requested that they sign on to our concept that the sign be no more than 20 square feet.
Do you have a mailbox post out front?
Yes, I do.
What if you put a sign, like, no bigger than that, like somebody puts a CPA or cabinet service sign about, like that, like small, not much bigger than the mailbox itself, on the post?
That's a great idea.
You know, that you've got a sign, it's not going to cause any notice or change the look of your house or anything like that.
I don't know, small thing, my house either. I want it to look residential.
And the other thing is that if you get mail to the house under the name of that business, it will help the post office know that they're delivering it to the right place.
Yes.
So what I wanted to do was say, God bless you, I hope you make a lot of money, but you don't need us, and I wanted to be sure Don put that in the minutes. And then it's official, if anybody questions, oh, he's doing this, he's doing that, the planning board said it. It's not, and I didn't want to say that over the phone or something like that to you, because we're only official when we're all sitting here in one room in a meeting.
What street are you on?
Douglas Hill Road. James Reese Sanborn's old house, they called the one that burnt down. That's the house. Probably pretty popular in town.
So thank you for coming in.
Thank you.
Good luck.
Appreciate it. All right, great.
Okay, back to Stony Brook. You can see why I just, I think it may take a little longer than that. So, this is now a closed meeting, and I'm not looking for comments from anybody. That's just the structure of planning board meetings. I'm looking for comments from the board. Any questions, observations, requirements that we want to this? I want your paperwork, and if you can give us a thumb drive, it's wonderful. We're asking for that more and more now. Seems to be the thing.
PDF version, I assume.
So, what are we going to, vote on approving the preliminary plan tonight? Yes.
Yeah, it's a major subdivision.
Right. Yeah, within 30 days from the public hearing or within 60 days of determining a complete application at the hearing, blah, blah, blah. The board shall make findings of fact on the application and approve with conditions of deny the preliminary plan, specify ratings, its findings of fact, and the reasons for conditions of denial. So do we have any findings of fact or anything on this? Besides, everything looks good?
Everything looks good. I mean, one of the things about the way the ordinance is written is basically, if we approve this tonight, it's a matter of waiting and doing it all over again, just for form's sake, which I hate. One of my hatreds of government, and government does that kind of thing too. It's stupid.
Then we just go to the final one. So.
We're supposed to do it in a two-step process. So, do we have a motion to approve this as a preliminary plan?
I have a question.
Yeah.
Is landscaper required?
By ordinance? No.
Landscaping?
No.
No, you just have open site, that's it.
We have not, we have asked for people to do landscaping. We asked for Mr. White to do landscaping, for instance. We haven't asked here. If you want to ask, then ask away.
I just want to know what the ordinance says.
The ordinance doesn't say anything. Well, do we have a motion? Oh, I'm sorry.
He has landscaping around the first one, I'm sure he's gonna put it around the others.
Yeah, I think there's some specimen trees that he'd like to keep, you know, for landscaping, some shading, especially the one, to the left. There's a few more trees on that side, but there's some young understory on the right side that, again, for noise purposes, we probably want to have some buffering from Route 11 anyway. So I don't think Stan's plan is to obliterate and level everything out there, kind of selectively work around everything. So, and again, we've kept the point there in tree preservation for buffer purposes already.
Have all the fees been paid?
Yes.
Does the plan say anything about the ownership, like it'll be retained by a single person or anything like that? Like,
We can add that to the plan. It's just, at this time, that's what we presented, that's what we put on the application. But if you're comfortable, it's in one ownership name right now under Stanley Douglas. So, you can put in there that this is for rental purposes or something of that nature, so that it stays in play.
Well, I very much understand the idea that this will be retained in one ownership, unless we come back to the planning board.
And we can put a note to that effect as well.
Yeah, that would be great.
Right. The only thing I'm concerned about is that it's rare. I mean, we just don't have this in town, you know, having multiple dwellings on a single property.
I don't know if it's fortunate or unfortunate, but I think that's gonna be the wave as, you know, housing becomes an issue.
Get used to it.
Yeah, it doesn't, the only thing that concerns me is what happens in 5 years or 10 years. And this is a far more lucrative piece of project if you carve it out into 3 houses. You can sell the houses off, or as you said, a condo project. So,
Well, and if it works, to your point, if it works carved into lots, this is also a subdivision plan, so that would be adding a lot line that would require an amendment to the subdivision plan, so we have to come back to that happens.
yeah, no, and that's kind of just having that on the plan in some way, shape, or form might be beneficial, because once we sign the plan, memories stay on what we talked about versus what's on the actual document.
So we shouldn't have any objection to state law or your law anyway, so
Yeah.
this stating kind of the obvious, but to your point, if we all get older and we all change and somebody else picks this up, help keep it clear, no problem.
Yeah, I probably won't remember this meeting in 20, 30 years.
Minutes? Did you say minutes? So is the project everything outlined in red? So
Yep.
it's like a ship with a sail?
Yep. Yeah, you mentioned that before, yeah. Yeah, it is all this property. This is added in to give the density so that it can do the dwelling, but that is the shape of the.
And what's in the sail? Is that
That's
swampland?
nope, that's actually upland. It's kind of rocky and, but it's got some trees on it. It is all upland, but again, that density is consumed with the dwelling, so
Yeah.
you can't build anymore on that. Unless you add more land to it or. So it's consumed basically under the residential. You can go up there, you can harvest trees, you can walk around, there's open space, but it's consumed with the dwellings.
And in terms of your view of like state law, is there any way he can add any sorts of what they call them, ADUs on this? Would state law allow him to put any ADUs on this without our approval?
I am not sure of that answer.
Is there any way we could put on? I mean, is there any intent to add any additional dwellings on there? Yeah. So, is there any way we could maybe add something in there that this is the maximum dwelling units that will be placed on this?
Or if because we don't know, I don't think any of us know where this ADU law is going to end up. I still think we're getting it. We can just put on there if any other residential structure or ADU must come back to the board.
Dwelling unit, I think probably go broad. Yeah, that would make me sleep better at night. The ship that sails.
Because I've asked that question too about how the ADU complies with subdivision rules and definitions. It's very gray as far as I'm concerned, because I mean, the subdivision law says dwelling units, but they've tried to make ADUs exempt from that definition, but they haven't changed the definition, so it's very confusing.
Maybe dwelling unit or,
I can just say any dwelling unit.
Yeah, that's my concern, and I think if, as we have a discussion, if there's no intent to do it, and, essentially by agreement, we put it in there, as this is what the project is, I think I'm not sure it's legally binding, but it's certainly helpful to everybody to understand what the expectations are. We did a similar thing in the last subdivision that we did. I think it made it all.
Yeah, and I think that this is, the good thing about for you is this is both site plan and subdivision plan, so any modification for a new structure, could have to come back to this board regardless, so you get them two ways, not one way.
You recognize that the guy who was involved in the last subdivision hearing, Cognito.
No, he told me they fell out. I'm like,
Now he knows the definition of equal treatment. That's all I have.
So I have looked up, the ADU stuff. It says state law allows accessory dwelling units on single family lots. So I would say that would be a no.
Today.
yeah.
Yeah.
Very, like I said, it's a very confusing law, and I think the other thing is that's supposed to be designated for growth areas, and I don't believe this is one of your growth areas. So it all depends on how you eventually adopt that as well.
Maybe someday. We'll get consensus in the town and what we want to do.
But I'm fine putting a note for those two things.
That'd be great.
Within 6 months after the approval of the preliminary plan, the applicant shall submit an application for approval of the final plan at least 10 days prior to a scheduled meeting of the board, blah, blah, blah.
So do we have to notice a final, or do we, as with other things where we assume that because they've been noticed in the paper, if you were interested, you would have been here, and therefore we don't have to notice the next meeting?
I think all you have to do is, because you've hosted your public hearing, so I think all you have to do is just make public notification as you normally would, that it's before the board for final review, and it's up to you if you want to have the public allow comment if they do show up. Almost all boards do.
Yeah, sure. No, I was just wondering when, normally you want to have it yesterday, and so I'm just trying to say, when do we have?
It's up to us whether we hold a public hearing or not. It doesn't say that we have to.
I don't think, if we had cars piled up outside and 100 people in here, I'd say yes. But,
that's all that's called.
yeah, there's nobody here because of Stony Brook subdivision. Am I right? Yes.
And actually, at the sidewalk, people were in support.
Yeah. Yep. So, I really would love to have a motion to approve the preliminary plan.
I make a motion to approve the preliminary
You
plan.
made it, and the mic on my left seconded it. And all those in favor? Okay, so now, you'd like to have a date?
Absolutely. So you can have another application form.
Okay, we probably want to notice this in the paper. Can you do that, Don?
Yeah.
And we want 10 days ahead of time. So actually, Thursday the 12th would work, wouldn't it?
January 12th?
Yeah. Have a public hearing and a final
Okay, fine.
Yep.
And are we or you responsible for notifications of that?
We are.
Okay, perfect. And 10 days prior to that, we need to get you a updated plan with notes, PDF version, and a
Yep.
new application form.
Yeah, and just deliver it here somehow.
Okay.
There's a $25 per lot or acre fee for the final plan, payable by check to the municipality, blah, blah, blah.
But, don't just deliver it to the town, you gotta deliver it to the planning board.
Okay.
Because the town sometimes doesn't know what it is, and
Yeah, I've
You know.
come in and, yeah, usually I put it on the code office.
it's not their business, so they don't know it. You know, I get it, I get it.
Well, when we submit it, I'll email you to let you know that we dropped it off.
Okay, great, that would work well, thank you.
Have you gotten all the approvals that you need, the DEP,
There's no DEP required approvals.
Maine Department of Environmental Protection under the Site Location and Development Act?
No, we don't trip that.
How about DOT?
We do have a DOT entrance permit, which I believe we provided to you. If not, I'll make sure it's in the final packet.
So you don't, Maine Department of Environmental Protection under the Natural Resources Protection Act, or if the stormwater management permit or wastewater discharge license is needed?
No, we don't meet either threshold.
You don't need Department of Human Services because there's no public water system. There's no subsurface
We have,
water disposal system.
well, we have provided you, the independent HHE 200 forms for each of those. So they're in your packet. Or we can put, I'll add it to the final packet if you want.
You don't need one from the Army Corps of Engineers.
No
That's
wetland,
a permit under section 4.
no wetland impacts, no wetland impacts, no significant wetland impacts.
Okay? So, we're gonna move right along and stay for good. We got a letter from our code enforcement officer, and he suggested another way of dealing with staying for good.
It was just only a opinion.
Well, that's fine, we try to give everybody a chance to talk, and, you know, we appreciate you looking into this.
Has everybody on the planning board read this? Does anybody have any comments, questions, perspectives on it?
I had one large concern. I tried to look down the road, as we were just doing, wondering about what happens if things don't work out, or you want to divide it up even more, or whatever. What happens to those dwelling units?
Yeah, that's a great question. So obviously it would depend on which direction we go. The initial plan was foundation-based cabins, so not your RV type. They would basically be a full-size home, around 700 square feet or so, bathroom, kitchen, the whole 9 yards, washer, dryer, hookup. So they could potentially be housing after the fact if needed or wanted. I don't have any desire to go that direction. I also don't want to build any more than 3. However, thinking about the campground aspect, I may need more leniency to go up to 4 because I'll be losing about 12 months-ish worth of revenue. So I had intended to keep one of them year-round and the 2 9 months out of the season thereabouts. So I don't know if campground, looking at that, if 4 would be allowed on the site, and I would also have to change models to like an RV style, which I'm open to as well. There's flexibility there. But yeah, that's sort of the thought behind it. I don't plan on separating it out on the line. my family or whoever, you know, inherits it, you know, I want them to be able to do what's best for obviously the Baldwin community, but also for them. But that is not my preference. That's not that.
So that's my concern.
Yeah.
That's exactly my concern.
No, I understand, yeah.
You know,
Yeah.
you're not gonna live forever.
I don't want to.
You know, and you may run into a situation where you wanna sell it or
Right.
whatever, and so that's my concern is sort of when your vision is no longer in
Right.
control,
Exactly.
what happens?
Yeah, so I'm hoping my vision would be adapted thereafter, because I really just want to build a place to enjoy the nature of Maine, that's the purpose behind it. But I mean, I can't foresee the future after I don't exist. It's definitely not my plan. So I don't know, be happy to write, however he's writing in application-wise, you know, things coming before the board, you know, issues writing things in, as far as like making sure there's re-review and, approval from the guy.
So I'm wondering, I don't know what the legalities are here exactly, but your 2-acre lot that's below 700 feet,
Yeah.
could be your permanent house. And if you wanted to put it under a separate deed.
Yeah, and I sort of think, again, this is all new to me, and I appreciate all of you guys, you're super awesome about explaining it. I had that thought, like, and that was my idea, the 2 upper cabins, the 2 clearings we went to, those would only be the seasonal ones, and that bottom one would be the year-round. So I didn't know if that was an option to split it off. It's 22.9. So if we make the assumption that we don't have the full recording of exactly 2 acres, Jamie and the team will obviously help with that, but the assumption of the 2 acres is in the rural district and the remaining is in the highland.
Right.
So it meets that maximum, 1 dwelling per 10 acres in the highland. So that would cap off any building more with those 2 above, and it meets the minimum required for the rural. So yes, we could do it separate, we could do it that way. I don't know if that means like just residential housing on one and campground on another. Again, ultimate flexibility.
What are the rules on campground? Is that that's in the land use ordinance?
Yeah. But campground just says tents, trailers, and not more than 6 months per year.
10 trailers, can that be tents or trailers?
Tents or trailers, it mentions.
So how many trailers
Not
per acre?
more than, it doesn't say.
So that's your
Potential
answer.
for growth.
If you separate out the ownership in 2 different LLCs,
Yeah.
then you can do something different
Okay.
with your highland.
Yeah, I could potentially so I have the business LLC, I have that created now. So I'll put the Highland in LLC and I can hold ownership of the lower portion. That would be a way to do it.
But then the lower one would not be a subdivision, would it? It's just.
It would just be a dwelling
Yeah.
house.
A dwelling unit.
Yeah.
I think she'd have to come back a lot, yeah, just hit my toe in early, that's all this, yeah. I think the lot she has is carved off in 2022, and so to carve off one more lot, you have to either wait another year and days, or go through a minor subdivision process for the lot split there. My question with campground, and so that's all I was thinking about this, is the ordinance is very concise on what a campground is, and I was just trying to pull it up before I start speaking to that form. And that some form, the RV one will meet her needs as well. Our recreational vehicle definition, the town has, will meet that need as well. And then if that does, that sounds like a site plan for, the 2 units there, and then minor subdivision applications to break off that one.
Yeah, and honestly, as far as, you know, if we need to wait for that 5-year marker I'm totally fine with phasing it out too, because as we've been going through this last few months, costs of everything have gone up as I'm like working with different, cabin builders and so forth. So, to space it out and wait another year before building that lower lot or piecemealing that parcel off, as long as we can move forward with the campground to the top one, that works for me too. So I'm not in a rush. We don't have to do all 3 at once. It actually probably work in my favor as far as like cost and just like that. Absolutely.
Well, I think what you've gotten tonight so far is that there are possibilities,
There
more
are.
possibilities and that we are sympathetic to you and trying to do the best we can. But,
I appreciate you guys, I do, very
um,
much.
I got one other idea, like,
Sure.
I want to muddy the waters. One of your conditional uses in the Highland area is a commercial outdoor recreation. And the cabins, while not dwelling units would be considered a structure, is there any avenue through that?
I'm not appreciative of that.
I'm drawing, muddy the waters.
No, that's fine.
I looked at that and didn't see any, you know, it's not activities, not dwelling units. So
Yeah, I was reprinting around the enjoyment of the land would be the use, and then the structures would be the accessory to the use, which would be enjoyment. So again, just trying to find a clean path forward for if you could call it a shelter like it, or something like that. No, and again, I know these, when we start to find using the land use here, I want to make sure we're sitting in that box perfectly.
Yeah.
A tent site, well, it says tent specifically for shelter site. Commonly in campgrounds or shelters, like we can do small cabins.
I don't think that would
campgrounds. That is what they're saying here, is that just a catch-all for any place to put a tent.
I encourage that, a different place to put a tarp or something.
With land treatment. What page? I'm still trying to find it over here.
Page 43.
Would you like to do individual septic tanks?
So, what I'm hoping is we can do one use gravitational feed from the upper two, cabins down into the main, and then the lower level one would have basically, parallel with that cabin. But we haven't done soil testing or any of that, so I'm open to that. I'm hoping to also do one well, if not two, one at the upper, two cabins that would be shared and one at the lower. Because the existing well house has been out of use for a very long time, so I don't anticipate using that.
Right.
That's all I need to reach for that. So there's a good space. I'm not an expert, that's why I got Jamie. From what I can tell, at the lower level, that would be a good place for like a leach field or something like that. That would turn into a walking meadow and, you know, pollinators, flowers, and so forth.
So I think the requirements in terms of density are that each site will have 5,000 square feet, not including roads and driveways.
Let me do some quick math. I thought so.
I mean, we're, you know, the amount of sites has not been a real concern.
Yeah.
You know, because we're expecting that it's only occupied 6 months out of the year.
Yeah, if we separated into the two upper cabins as campground, yeah, 6 months out of the year.
So you're getting a direction here.
Right, exactly, and that would work.
To decide where you want to go.
Yeah.
Up to you.
Yeah. Okay.
Kent, as the author of this and wanting to do review path clarification, what are your thoughts on?
Well, I brought it up because there was a mixture of terminology that saying dwelling unit to me means housing, like single family housing. And then there was transient lodging, which means like hotels and stuff like that. I just wanted to have a little bit more clarification. There was potential for, you know, like a group, like a one drain field for all, which would make it more, you know, for cabins and stuff. Or if they were all individual, then I would be on board with the subdivision, because that is, it's just, you know, you're just making a house. If you have a foundation, a kitchen, the whole 9 yards, and
Yeah.
I'm looking at it as a house now.
Yeah,
Or a
the
dwelling, I should say.
model that I'm favoring currently is an A-frame style house, but it has all the features of a full house.
So you and I have the same concern, is what happens next?
Right.
And
Right.
so we're saying, if it's a site for an RV or a tent, which means a prepared site and you flatten the dirt, then that's every 6 months, you get out of there and leave it
Right.
vacant for 6 months. That's something different than building houses.
You're right.
They're houses if you build houses.
Yeah, and I'm open to either direction.
So that's up to you.
Yeah, the split where, you know, we split the property and we do RV camp style campground 6 months out of the year. And then the one, you know, A-frame down on the lower level, that's a full house. Or the original, the subdivision with 3 A-frames as a full houses.
Yeah, that's up to you.
So I studied all of the subdivision ordinance and the land use ordinance, and I looked up all the definitions I could. I couldn't find the definition of transient lodging in either ordinance, and I couldn't find the definition of residential occupancy in the subdivision ordinance. But, you know, if you just look at the basic definitions of subdivision ordinance, page 6, dwelling unit, a room or suite of rooms used as a habitation. You know, so if you build cabins, the A-frames,
Mm-hmm.
you know, they're dwelling units. A subdivision, the construction or placement of 3 or more dwelling units on a single tract of land. So you don't have to subdivide or have separate lots
Okay.
to have a subdivision. You know, just building 3 or more dwelling units on a single tract of land. That's page 9 of the subdivision ordinance.
And that's specific to minor subdivision, right?
Yeah, minor subdivision, unless there's a proposed street. If there's a proposed street, it's a major subdivision. You know, and a campground, you know, specifically mentions tents or trailers and not more than 6 months a year. So based on the discussion we've had tonight, if you shift your direction to have, you know, RVs,
Mm-hmm.
or, you know, movable
Right.
homes, that sort of thing, even a tiny home on
Anything
wheels.
not attached. Yeah.
Right. Then we could go the campground route,
Okay.
up higher. And then, you know, the house down lower would be the minor subdivision. But if you want to do the A-frames, you know, all 3 A-frames or anything, it seems like we'd be safest, or at least most in obvious compliance with the ordinances going the subdivision route.
Okay.
Now that said, I want to compliment Kent on his out-of-the-box thinking in going this way, and I think it's his experience as a CEO with the, you know, the concepts of transient lodging and residential occupancy and things like that gives us the ability to look at this kind of out of the box, which I tried to follow, but I just got confused.
No, I appreciate it too. I like to know all options.
Get back in the box, you'll be fine.
You know, that's the janitor. Stay in your box. Stay in your box.
Okay. And then just a quick update, from when we met last on site, I did get the right of way deeded access, so it's in the deed now. I am also working on drafting a plan, with my lawyer so that I take some financial responsibility of it. That was my suggestion, just to make good partnerships with the neighbors and the previous owners. So I'm in the works on that. Additionally, there was a last minute, notification that there is a well in the very top corner that belongs to one of my neighbors. It is the dug well, so I'm also working on permission of use for that neighbor. It should not be anywhere near anything that we're building, so it shouldn't affect, there should be plenty of frontage or,
Separation.
what'd you say?
Separation.
Thank you, that's the word I'm looking for, between like where I am and what they're, like, way up at the top, line uphill. So I'm working on that as well. Those are my big updates. I was going to come next month. Do you still want me to stop by, or I know Jamie had initially said he was going to have something ready for March, but with this change, it might be a little longer. What are your thoughts?
Yeah, circle the wagon, just take the options away.
And read through, yeah. Okay, that sounds good to me.
Have we given you enough clarity for the path that you know how to proceed?
Yeah, I think just to throw a few things out, if we go to subdivision road, I think you're gonna wanna see individual septics, serving each lot to future-proof it, and I think for Joe, I think for the board, to future-proof it, either with a site plan or a subdivision, just having location on the plan that years from now frames up what's gonna happen.
Yes.
Familiar with that.
Yeah, I think I'm good, and I have your number if I need to ask questions. So yeah, some thought into it. Anything else from you?
You okay?
I am. I'm processing it all. I'm
Great.
very tired.
Great.
Okay.
Have a nice warm weekend.
Yeah, you too. Everyone stays safe, and we'll see how the storm goes, right?
Amy, very nice to see you again on another project.
I think it's not the town line coming in, to be honest.
We have a tracker on your truck.
Even my wife.
Thank you guys so much for seeing everyone. Have a good night.
So, all of you got the letter from the selectmen to the planning board? Any comments?
I think it's kind of a theoretical issue at this point. I mean, we don't really have anything in front of us that requires us to consider the ratification of the letter, but, you know, I don't think I fully appreciate what it means until I have confronted with that question of, is there some state law that I feel like is applicable to the situation, and it's not necessarily addressed by the ordinance. But I don't think there's anything in front of us that requires that sort of question at this point.
I had a question. I just wanted to get clarity on this one thing. There's a sentence in there, the next to last sentence, that says, you also have no legal authority to attempt to implement state statutes without approval of the legislative body of the town. So I understand that the legislative body of the town is what happens at the annual meeting. At first I thought it might be the selectmen, but I've since learned that it's the legislative body of the town is the voters. But I just wanted to understand what we were trying to do with that sentence, no legal authority to attempt to implement state statutes without getting the ordinances changed, I guess it means. And I just wanted to understand that a little bit better to make sure that we don't inadvertently attempt to implement state statutes. You know, what was the thinking behind that sentence that we wanted to make sure that we didn't
A discussion last, planning board meeting about state law, perhaps superseding our ordinances. In other words, interpreting some clause or something in one of our ordinances to say that, you know, anything more stringent or, I don't know, I would think about it, but because there's a state law that says this is legal, that you would implement that and supersede our ordinances. clarification enough? I know Dave expressed the concern about it, and I think maybe you did, Matt, as well. And we had a lot of discussion with the attorney about this, and he was quite clear that we implement what the ordinances are, not what we think they should be or what they state law is. And that's why I was put in there, just to put to bed that one particular issue.
I'm always very suspicious of lawyers who agree with their clients. You know, because they're paid to do it. They're not paid to disagree with their clients, they're paid to agree with their clients.
So basically, it's saying that we implement the ordinances as written. And if somebody comes to us and starts spouting LD 1829 or LD 2003 or anything like that, and they submit a CUP or a subdivision request that is in alignment with state law, that we have to make sure that we don't be sympathetic to them and say, oh, well, this is state law, so we're going to approve it. What we instead have to do is reject it and just administer the land use ordinance and the subdivision ordinance and the shoreline zoning ordinance as they are written, unless we take one of those ordinances to a town meeting and get it changed to be in alignment with state law. Did I get that right?
No, because in that case there wouldn't be an unless.
Right. If we get the change, then there's no contradiction.
And the one thing that he added to the letter, I drafted it based on what we were talking about, but he added the last sentence.
Right. Appeals board. Appeals board.
Yeah.
And actually that made a lot of sense because that's what we have been telling people. In fact, I remember telling the fellow that runs the Whistle Stop when he wanted to know how many dwelling units he could put into a house if he reconstructed it. And I told him that if he wants to do more than two or whatever it was, that we would have to deny it because that's not in our ordinance, and we would have to take it to the appeals board.
Just to add to the discussion, we talked about what happens when somebody gets to the appeals board on.
Yeah.
The city appeals board would have to abide by that same ordinance, the notes that we have in there, or the direction, and deny it. The appeals board can't say, I'm going to negate the town ordinances.
Right.
And so the next step would be the applicant willing to take it further.
Right. And then we would, I assume, capitulate to avoid legal fees.
But again, how it doesn't, you'd have to go to court to see what the judge says.
Yeah.
Because again, you can't do anything because you don't have an ordinance to do otherwise. Right? So, you get into a lot of speculation.
Yeah.
It's not an uncomfortable place to be. It would be best to have ordinances.
Right.
Keep us in compliance.
Yep.
We can.
So in the meantime, it's going to be a team effort. We're going to need, our interpretation of the ordinances, Kent's interpretation and experience, and the selectmen too, as we all sit in here to make sure that the planning board doesn't, inadvertently, allow, something to slip through that is not in compliance with the ordinance, but is in compliance with state law. We're just gonna have to.
I don't know how that could happen, I'm very good at enforcing state town ordinances as they're written.
Yeah, but, it's not that we haven't made mistakes that have caused us to wind up in a sticky wicket, so. All right, so this should be asterisk and say, talk to Bob. Thank you.
Does anybody else have anything they want to say? We did talk about looking at our ordinances and seeing what we could do to revise our land use ordinance, to bring it into compliance, but be as close to our old ordinance as absolutely possible. And I called up Southern Maine Regional Planning, and I did not get a return phone call from what's her name, Jordan Michaela, because she doesn't work there anymore.
Oh, she
She left. And so I talked to Jamal, and Jamal is looking to hire somebody. In the meantime, in the next week or two, he'll get together some sort of a proposal, and we'll see where we go from there.
I had mentioned an idea to Joe. I mean, this is a very fraught topic. Wyndham has filed a complaint and is writing letters to the state opposing the legislation in 1829. So has Scarborough. People are confused, they're opposed to it, and they're fighting it. And I guess it is kind of like Lucy and Peanuts in the football. I didn't want to see us do what we did before and hire Southern Maine Planning and Development Commission, go through months and months of, and this was just on LD 2003, let alone another 4 or 5 ordinances. And, we came up, and we did that just amongst the planning board with Southern Maine. Then we had the meeting, and it was voted down. And I remember Norm, he kind of led the charge against it, saying that, it was a violation of home rule. And the problem is that he's right, but what the state legislature has done is they have designed these to supersede home rule. That is their intent.
No, I disagree. You're misrepresenting what home rule is.
How so?
Home rule says that we can write our ordinances except in those instances writes a law that applies to the town of Baldwin, then home rule is not the question. And it's right in the state law about home rule, it's right in the statute. So they're not designing these laws to kind of get around home rule, it's just a fact.
No. That's one view, Bob. I probably don't have the detailed view of it that you did, but what I've read in the editorials and from the committee members who drove all this legislation said specifically that they wanted to make sure that the towns, could not use home rule to block the increase of housing units.
No, that's right, you can't. Just by passing a law, it's a fact.
Yeah. Well, I really didn't want to get hung up on that aspect of the debate. Where I was going with this is that...
You say that it might violate some intent or goodwill or something like that. In other words, don't let the people do what they want in their own town.
So here's the...
that happens a lot.
Here's the question. How do we, or is there a way to go through this process again of trying to bring our ordinances into compliance with this legislation and take it to a town meeting or a special town meeting and not have it voted down because people feel it violates the concept of home rule. And I wanted to offer one idea. What this reminded me of was the way we worked on the comprehensive plan. And that is that the comprehensive plan wasn't just the planning board and the select board. We brought in members of the community. And I'm wondering if this effort to work on one other aspect is, I don't think there's any way that we can run this process solely during planning board meetings. It takes too long. It takes too long because there's so much to go over, so much legislation, so much to discuss, and it seemed like it needed to be a separate process with maybe invite Norm to sit in on it, invite some other people that we get buy-in and find the best way around the legislation that allows us to hold on to every shred of home rule or our own decisions that we can.
So there's a couple of options. One is just wait, and hopefully someone's going to change the law or something, right? And then, but whether that's going to work or not, I don't know. The other one is you have to talk to a wider audience. My impression is the first time we did it, we did pretty well, but there were a lot of people came to me later and said, gee, I was hoping that this law was going to allow me to put an ADU on so I could put my parents in it.
Right.
Or they could take my house and I'd live in the ADU or whatever.
Right.
So there might be more support for what the law allows in the greater public, but they were just waiting for it to happen because it's law, right? That's but you always have to take the risk that even after good public debate and information, and massaging it, if we get input that says, well, we'll agree with it, we do this or do that, then it still won't pass.
Yeah, it's always a risk, but we should learn from what we went through before and see if there's some way we can, something we can do to avoid the same outcome. That's just the thought I had.
Finding out why they opposed it so much. I mean, I know a lot of people saying that they didn't want somebody coming in and putting an ADU on a piece of land that somebody owns, and then turn around and sell it to somebody else and be a big mess. Could we restrict it to, okay, yeah, you can have one, but it's got to be a family member, or can we put more restrictions on it? I mean, we can allow it, but have a lot of restrictions on it.
I remember what Larry Lord told me about giving land to my son, which I did. He said, don't give it down the driveway, because then you'll find you're living, this didn't happen, but then you'll find you're living next to your asshole ex-son-in-law.
Yeah.
Yeah.
Well,
Let
me throw something in here.
Yeah.
We talked a lot about, revising our ordinance to come in compliance with 2003. The time and money and resources put into that, by the time you get it done, even if it does get voted up and down, guess what? You're out of compliance with 1829, which is supposed to be. So I would suggest focusing forward efforts on that, because it's going to be way behind us, and they've already made modifications to the LD 2003.
There's sorry, just to interject, there's a, I don't know what to call it, MOIDA or whatever. It's like the 5th of March or something that I'm going to. It's going to cover all of that stuff. They're going to do all the code enforcement officer training for that specific thing. I don't want to force it on anybody. They're going to go to it, we're going to report. Everybody.
No, I appreciate that. I know what information you're going to get. It's all,
I'm sure there's going to be a lot of people there that are going to have the same exact questions that we all have here right now.
I haven't seen the implementation guidance on 1829.
I attended the online Southern Maine Planning. This is the packet that they put out, and there were some implementation deadlines, and so there's a lot in here. But I absolutely agree with you, Dale. It would be foolish to go through the same process just for 2003, and whatever we do has to include 1829
and we'll just have this conversation till the end of time.
and the other things, and if we get the process started now and figure, that we get it done in 12 or 15 months, it'll be right around the time that town meeting municipalities have to comply with it in July of 2027. And hopefully we'll be able to figure out if there are any tweaks or changes or anything like that to it.
I'm very uneasy with being out of compliance with state law. In my old age, I even drive speed limit once in a while. I mean, I'm not comfortable with breaking the law. That's the way I look at it. I'm inclined to agree with Bob saying, we just let it ride and see what happens, because it's quite possible that we got an election coming up in November, and, it's a long way off now, but it's gonna happen, and maybe these laws will all go away. I have a feeling that we change parties in control in Augusta, they will. So, you know, it's just, the whole thing is just, there is no clear vision. There's no, this is the right thing to do. And maybe, you know, waiting, hearing what Kent comes back and tells us, maybe you'll get some real words of wisdom that we can use. Maybe
No
we,
pressure.
yeah, no pressure here.
Like I said, is I haven't seen the state, implementation direction for this.
They're not gonna implement
Huh?
it. They're not gonna implement it.
The state, for LD 2003, issued a package of implementation, and it didn't totally align with what the statute said. It did some wiggle room, you know, and I guess that's the difference between, what they write, you know, in Congress and what the agencies write for implementation. And, I'd like to see what the state agency, was it DECD or, no, it's,
MOCA, MOCA or something like that.
I wrote them some comments, because they had a area where you could write comments, and I wrote some very pointed comments about it. I'm really concerned about the density of, housing units on a lot. And, you know, where are you gonna get the water from? Where are you gonna dispose of the sewage? It would almost force some people to go to a community water system. And, but I haven't seen any feedback. They took my, they took my feedback, I know, because I wrote it to them, and I sent it through, my, iCloud account where it masks your email, so it doesn't really say who you are, or where you're from, or anything. So they came back and said, okay, I'm not gonna listen to you unless you identify yourself. So I did, but, I guess they're getting comments, I don't know. You know, it's unfortunate that they came out with this very sweeping change, and then came out with a fairly substantial one right after it. And we're not the only town that's gonna have issues. I mean, towns that have already done their updates are gonna be faced with kind of redoing it. And the impact that it has on, your zoning and, can be substantial.
No, they're constantly changing the zoning, and towns are having to update their comprehensive plans. Because
so anyway, I, did what I said I was going to do, which was give you direction as a planning board. And now the planning board, also committed to giving us some ideas on how to move forward. I think, Matt, that, probably what you're suggesting is probably the way forward, which is to start getting some community involvement. And, I personally don't believe that the laws are gonna change, at least LD 2003 laws. But they might have some twiddling with the 1829 one, but.
My experience, Bob, I don't believe that anybody, well, more than one or two people might become interested if we really had a big push to get people to come in to talk about changing ordinances. You know, I just, do you know anybody as interested as you or I or Matt or, you know, anybody in this room who that, but then they won't come to the meeting.
Well, I
That's what
don't
I'm
know,
saying.
but, you know, I think is, a lot of people have the same sentiment, and I think many of the other towns presented it slightly differently. Which is, this is just the state law, and we've got to do it. And people accepted it as such. It was presented as the ordinance was written, as the modifications of the ordinance was written, it was presented as that. I heard comments in our town meeting that I thought were just outright misinformation.
True.
And, whether you can sway people to, understand what the misinformation was, I don't know, you know, who says, but the vote was fairly close.
Yes, I hold out no hope for interesting more people.
Yeah.
You know, that's my experience is I will have people tell me, I'm really vitally interested in that. And, you know, looking for people to come onto the planning board. I hate to tell you how many people are in front of you, Mike.
There's a different way of handling it as well, and that is, how you do the vote.
Well,
Do it as a secret ballot.
I think it should be done.
That's not how we do stuff.
I think it should be done in an annual town meeting, not a special town meeting. Have a special town meeting, you know, you and 3 friends can sway the whole thing. And that's how much that vote was, like within 5.
Yeah.
You know, so within 5, it's 2.5 votes, changes everything,
Yeah, maybe, I don't know.
you know,
But it
wasn't that much.
Yeah.
So,
One thing I wanted to ask about is, are there any other consulting resources available to us besides SMPDC? You know, does MMA have anybody, or are there some other groups out there that we could get to bid on helping lead us through this process?
I could probably they've got anybody.
Yeah, because we were gonna have to pay SMPD&C something, for this, but, maybe there's other folks out there that, aren't stretched so thin.
thank you, Kent. Great idea.
I got a question. What does the select board think about what I said about the fact that what you guys voted on was the ordinance language, not really the ordinance?
I'm not sure I understand.
So you rewrite out the ordinance to cover LE 2003. You brought it to the town, and the town voted no. What I'm saying is, my opinion, is I think the town voted no on the draft language for the ordinance, and that the state laws are still there. It's just we don't have an ordinance that is up to the laws. It doesn't mean that we still have to fight the.
I'm sure I don't understand where you're going. You get the, you know what you're talking about?
No.
How you,
I think that's what the letter is for.
Was it?
Yeah, to say, if we don't have an ordinance, it's outside your purview. So there's no ordinance on ADUs, so it's outside your purview.
it applies not just to these ordinances, which we're talking about, it applies to any ordinance in town. If it's outside of state law, what we have still is what we're supposed to do.
Right.
So,
Is that,
Yeah, outside of state law.
what we have is contrary to what state law says, we still enforce town ordinance.
Right.
But it also, if we don't have something that covers the same area as state law, you're saying,
State law.
I thought you were saying it's outside our purview. So if there's, if we don't have an ordinance on it, we're not supposed to apply it.
I can imagine what that would be, but, with what regard. I mean, most of the things that the CEO and the planning board get involved in are written down in an ordinance. Now, there are some things such as implementing things like availability of septic or whatnot that we don't have an ordinance that specifies, but he's got direction as a licensed plumbing inspector that tells them how to do it.
But aren't there some state laws that say, the town can choose a particular path, but if it doesn't take a particular path, the state law applies?
That's what I'm.
Yeah, no, I'm getting there.
Okay, sorry.
Which ones they are?
Part of it's the journey, you know?
So which ones are they?
Oh, well, that's why I said I don't think this is teed up for us today, because I'm not sure which ones would be in front of the board. But I mean, like the subdivision law, I mean, there's a state subdivision law, and we have a subdivision law.
Which I'm not in compliance with.
Well, I guess I'm not worried about compliance or non-compliance, but like, if there's a part of the subdivision, the state subdivision law that we don't have anything, we don't have, medical marijuana might be one too. So, you know, if we don't have a medical marijuana, ordinance, I thought the state law applies. I thought there was, no, but you're asking for examples.
Okay.
So, I mean, I'm just giving you, like, I don't know, I haven't read the ADU stuff, but, I don't know what they say, but there are state laws that give the town the ability to pass an ordinance, and if you don't pass an ordinance, then state law applies. It's like medical marijuana. And so, I think the question Kent's kind of putting out there, I think, is in those cases where it's that situation, would the planning board and the CEO apply state law when the state law is constructed in that manner? And the way your letter is written is you only apply the ordinance that's in front of you. You don't worry about other authority that the town hasn't adopted. And the way you phrased it was essentially, if it's not in the ordinance, you decline to take action, tell them to go to the Board of Appeals. The Board of Appeals declines to take action, and they can file a lawsuit, and lawyers can figure out if the town has to allow them to do whatever they're trying to do under state law.
Well, I don't know, and you have to go find that law and say, because that's a very speculative thing, because I'm not sure that there's any area that Kent would be involved in, or the planning board, that is not covered by our ordinance.
Okay, and that's why when Joe asked if there's any comment, that's why I said I think it's theoretical, because the issue's not teed up for us, but we'll have to see what happens if the issue ever gets teed up for us.
I do know that there's a couple of ordinances that the town has written, and they have disappeared. Well, there is a town building ordinance. Passed and modified several times. I think the latest is about 2012. I found a lot of the amendments. I found the original and the amendments up to a point, but at some point, the planning board took to the town a statement to the effect of the amendments as presented in the handout or whatever. And we don't have the words to it, and it's just,
What's the build, what was the building on this?
how you build a house,
Yeah,
building codes.
Oh, was it my, building inspection, pipeline or whatever?
We looked at that,
I don't remember.
that doesn't jog memory to me.
What do you mean?
Before I got here.
I don't remember looking at it. Building code.
I think 2012 was the latest amendment to it that passed the town meeting.
Well, that's different than, you said we did something, so did.
Oh, I said the planning board, I didn't say you specifically.
I don't know how involved the planning board was.
And, but when I go to look for a copy of it, can't find it.
I don't think there ever was a copy of it. I think all the.
Well, I know there was a copy of it because when my house was being built in 2010, they talked about it and how much insulation the code required to put in the attic.
Yeah, that doesn't, I mean, I don't think I would remember it, because that would be curious to me why we would be doing that.
Why?
Why we would be looking at the building code.
CEO.
I always thought that was the CEO, and they just we followed, but there's a book we followed. There's like-
Sometimes, so, sorry to interrupt, MUBEC is the main state thing that we
Yeah.
did not adopt because it also includes the energy part of it as well. I don't think we want anything to do with that energy part. So the building codes are still there, but not at the town level. They're at the state level. They're the IBC, the ICC, or IUDC or something like that.
Yeah, I was.
But I don't have any authority to go and inspect it. It's not written in the ordinance to go and inspect it, so.
But that's a good point, though. I'm familiar with the building code, I'm familiar with the residential code at the state level. They're very clear as to what's required by a town. And what happens is when you, in a case like Walden, we have home rule. Now, do we have to, can we use home rule and just use the CEO's experience to do the inspections? Or are we required to do it by the IBC or the RC?
Well, I don't think the state codes apply to Walden because of their size.
That's correct, the code, I don't think.
But there was one at one
But
time.
there is one over that.
And it disappeared.
But I'm saying, there's a code in the state that says you need to follow these certain requirements, IBC, IRC, it's very clear. They require the energy code. Can't we just say, well, maybe we shouldn't need to fool around with energy code, but suppose somebody came in with a commercial building, we would definitely need to go and do the energy code.
I remember a physical code when we did the 1996 or 1998. But I don't remember a physical complete book since then. You know,
I
we
don't
might
know
have,
that there's a book, but there's an ordinance.
maybe an ordinance that was passed as, we're gonna add these sentences.
Yeah.
Rather than, we're gonna take this book and throw it out and adopt this one. I'm saying, I think the last physical book
Well,
I saw.
it started at one level and slowly progressed over time, you can see in the amendments.
Yeah.
But it was something to the effect of add these words or whatever,
Yeah.
but the words disappeared. I can't recreate it from anything that I have found or that DevTree provides me.
But that goes back to the question. There is, if the town doesn't have a building code, or building ordinance, the state does. Do we still have to follow, we should be following the state?
I don't believe, and Ken can answer me, that the state rules on building codes apply to Baldwin strictly because of the size of the town.
I understand it, but I think the state,
Has some, but you don't have to follow them.
I disagree with that.
Less than 4,000.
Yeah,
I think you do, right, Ted? I would.
But they're not, with MUBEC, they're not gonna come out and inspect anything residential at all. They don't have the
They don't have staff.
manpower for it. They will with commercial. And that's, from all my stuff that I've read, that's, if like Hannaford came here and put up a commercial building, yeah, they gotta go through all the.
And they gotta go through all the codes. The IBC, they gotta go right down the list. Now, who enforces that? The state enforces that. Right, Kent? We have to call them up and they would enforce it. That's what you have, right?
Right.
For residential, you would still handle it yourself.
No, because it's not in the ordinance.
So how does that get, residential get inspected?
It doesn't. Only plumbing.
But you can still go back to somebody that's building.
Yep.
Says you gotta build just, whatever you're building, it's gotta be in accordance with the IBC and the IRS.
Yep. Yeah, what I can do.
You can say that to somebody.
Yeah, I can put that in all I can do is put something on the building permit that says you to follow all state.
And it's up to them to enforce it.
Yeah.
Yeah, it's a regular homeowner.
Yeah, I don't like doing it that way, but it's, fully involved in running, so I'm not
And
gonna.
that's how you give a permit, because you put that statement in.
Right.
You give a permit.
So far, there's no permit. So far, there's no permits.
You can build permits, you get foundation permits.
So let's get back to where we entered this conversation. Where are we? Do we want to sit back and have patience and hope and pray nobody comes in and embarrasses us? Do we want to try to rewrite our ordinances? Do we think the ordinances, the state law rather, is going to change fairly shortly in 2027?
Yeah, that's July 2027 is when town meeting municipalities have an implementation deadline for 1829.
But if there's a political shift in Augusta, maybe these laws will not look exactly the same way fairly soon. And in the meantime, we spent $15,000-$20,000.
Then they change again.
Well, I would posit that if we do the process correctly, I don't think we would lose $15,000 or $20,000. You know, this is not something that we're going to be able to do in 3 months. You know, and I also don't think, I think we have a fiduciary responsibility as a select board and a planning board to at least make an attempt to keep our ordinances in line with state laws, because you know, David sent us a document tonight, which is the MMA's planning board guidelines, rights, regulations, authority, how you do this, how you do that, everything. And we were particularly interested in what it said about liability, and does that document support this concept of not being liable for being out of compliance with state law? Well, it does, to a point. There's two concepts: good faith and negligence. And that's everything we have to do has to be in good faith. And as a board or as individuals, we cannot be intentionally negligent, so that somebody who comes to us and asks us for subdivision or CUP or anything like that gets intentional bad advice, or we're negligent in giving them their advice. If that can be proven, well, then we do have liability. So my feeling is that we should be making some kind of an effort to bring our ordinances into compliance with state law. Let's take an example. how long did we spend on that fucking comprehensive plan? You know how long? 3 years. 3 years we were working on that. You know, and, you know, when you add all of our ordinances together, I would say that the minimum amount of time that it would take to rework those, 6 months at an absolute minimum, more likely a year or 18 months. Given that we can't meet constantly and that we're going to have to be aware of tweaks or changes, but you know, this is it's a process that we should get started on and try and remain somewhat flexible. I personally think that we would be negligent if we just waited until July 2027 when the laws are implemented and then said, oh, now we should try and update our ordinances. So
I need some help, in the handbook from the MMA.
Yeah.
I was unclear. I thought it said that we're not liable for the first $10,000 in damages. But I was unclear whether we were liable if the judgment was more than $10,000.
I didn't pick up that 10,000.
I agree with Matt. I think we should,
Can I borrow $10,000, Jeff?
Sure, any day, yeah.
at least just press on and,
I'll look at myself.
you know, I mean, I think we want to try to meet with the community and tell us why they voted it down and try to rewrite it in a way we think it might pass. Might take a while, might be quick. I mean, I don't know. But, you know, we created with that ADU, we created the more lenient approach, which is, you know, we'll recall how that was done. And I think there was a decent amount of people who may have been okay with it if it was more restrictive. And maybe limiting it to relatives. I don't know if we can do that, but you know, or limiting the size, or you know, there was like 10 or 11 variables that we chose to make it bigger and more applicable. Maybe if we narrowed it down and said, look, the law tells us we have to have something, and this is, you know, the most restrictive or whatever. Maybe that
minimal compliance.
Yeah, yeah. Maybe that'll be more.
I think the ADU part was the least concern. I don't know, but all the added density that housing struck me.
Yeah, yeah. Well, I mean, like I said, there's like 5 or 6 levers that we could look at and say, you know, should we tighten those up? And then we have the argument that, you know, we're doing the best we can with the next statute.
So what I'd propose is that then we wait, we'll hear from Ken if he comes back with any revelations that we ought to deal with, or he comes back with a recommendation of somebody we might talk to or might talk to us, and give us some advice. And then we set aside a Thursday, not a second or fourth Thursday, but a Thursday, the first or third Thursday of every month. And we spent that one day, one evening, dealing with this.
Workshopping.
Workshop.
It's like March 5th or something like that.
That makes sense.
And, yeah, look it up that way.
You know, in my career, I've hired and done projects with a lot of consultants, McKinsey, Boston Consulting Group, a lot of them out there, small ones, big ones, things like know, there are consultants that have ulterior motives and are recommended to you to work with you because they're taking direction from somebody in the executive suite or something like that. And, you know, those projects are always difficult because, you know, they have a consultant working with you that has more in mind than what you as the client want. It's like hiring a lawyer. I mean, you have good lawyers and you have junkyard dog lawyers that, you know, when you want to tear somebody's leg off. And the point that I'm making is that I would like to see us hire a consulting group that understands the concept of minimum compliance and maximizing the aspect of home rule and the things that we can maintain control over, and whether there are any loopholes that we can leverage. Somebody who is truly working for us that doesn't have, that isn't getting money for their organization from the state. You follow where I'm going with that? So that's why I would like to have a little bit of choice and, you know, look for somebody besides SMP and DC. You know, there's got to be some more people out there.
Well, one of the things, the area we have to examine in inviting people in is what do people involved want to do? I mean,
educate them on what the law requires, and then get a more comprehensive feeling that the people involved understand what the options are, and then we'll go forward.
David's talking about the levers, and I'm thinking, well, what levers do other people want us to pull on? I don't know that I care. I'm not committed to any particular point of view on this. I probably would be concerned if there were, you know, I am concerned as Senator Blackroad goes from having, I don't know, 7 or 8 houses on it to 30 houses now. I used to ride my bicycle there and coast down the hill and, you know, never worry about cars.
Just chicken.
Yeah, just plain chicken.
If you don't want to see an ADU, if anybody's never seen one, go on Houston Road and go down to Gorham. How can I describe where it would be? So you go, you know where the municipal buildings are? Houston. You go down Houston Road on the left, going away from Baldwin on the left-hand side. There's a relatively new house, and there's an ADU behind it, and it's a perfect example of an ADU situation. Whether you like it or not, like if you've never seen one, very small. It looks like a outhouse, but it's an ADU.
No, I don't know if I care. I mean, you know,
it's an interesting. I was surprised to see one there.
What was your impression? Good, bad? Too big?
I wouldn't want to live in a town that was populated by a bunch of little ADUs.
Well, yeah.
I mean, I wouldn't want to live in that house.
Well, you wouldn't want to live in that house, but
either one, the ADU or the adjacent house. Like you have somebody like right there.
Yeah.
One of the girls in our office she's
What we have
putting an
now in our
ADU
ordinance is
for
you're
her
allowed
mother.
to put a trailer beside the house.
And it's 750 square feet. What they run into right now is they are requiring all units to have the water, sprinklers.
Yeah.
But in their ordinance, it says anything under so many square feet, you don't have to have it. She's under that square feet, but she's gotta go to the Board of Appeals now to.
Sprinklers and those.
One of these ordinances says that you cannot require sprinkler systems in ADUs.
So you're making them not cost effective, no?
Because that's what people did when 2003 came out, is they said, oh, we can block these ADUs, we'll just make them have sprinkler systems. So this group paid attention to all the ways that people were getting around and blocking ADUs in LD 2003, and that was their focus when they did LD 1829, was plugging all those loopholes.
Loopholes, it's not really a loophole.
Well, the language wasn't as strong,
Lawyers,
apparently.
I live in loophole land. But I think, going back to, like, where do we go? I think we should probably start having meetings in April or late March and about, what can we do to fix this? It's our job.
But directed by somebody else being responsible for writing this. I guess we've got to organize what it is we want.
Yeah, that's the first step.
Yeah, you're right. Okay.
We need to work on a statement of work. So something that we would give to different consulting groups to have them bid on.
Sure. Let's get February project. Kick the can down the road. Do we have something for the first one? We could probably just regurgitate that when we have Southern Maine planning work on it. Do we have a
We're just in the room when we
I don't remember. I know we had that statement of work for something they did. I don't know if it was that or something else.
I'll look and see. Some of the stuff, I wrote the statement of work to get them on board with marijuana issue.
Yeah.
And maybe we addressed it. Okay. I don't want to leave with the impression that Michaela and group did us bad, because I think this group did a very good job of minimizing the impact of LD 2003, and so they listened and they just helped you write it. That's all. Put it on the paper, and they did a lot. I think the other thing they did was they cleaned up the ordinance a lot and made it more in line with what most town ordinances are. The tables and whatnot are easier to read, straightened out a number of things. There's a lot of work went into that draft. It's good material.
There have to be consulting groups out there whose core competence is writing ordinances. There has to be.
So that's your assignment for next meeting.
These ordinances don't write themselves.
That's the town planner?
Town planner?
Yeah, that's the town planner that does that?
Yeah.
Waterboro has one. No, I did mean that. I meant in general, the town planner does that.
I've never seen a description of what a town planner does. They,
Taking a shot in the dark.
huh?
I was just taking a shot in the dark.
Well, I've heard the term, and I've known a number of towns have them, but I haven't seen a description of the job.
We could ask. Remember whatever his name was, not Harvey Oswald,
Lee J. Feldman.
Lee J. Feldman He is now the town planner in Kennebunk, or Kennebunkport, one of those two. And then the, person that he hired who first started working with us on the comprehensive plan before Michaela came on, is working for him there. We should ask around and ask some people like that who some of these, consulting groups are. That we could talk to.
Archipelago might be one. I think they've got teams of lawyers, environmentalists, whatnot.
Fascinating. Yeah.
I mean, if you look them up on the website, they, multi-function operation.
Like an archipelago.
I did a quick search, I was right about the town planner. Professional staff who make sure the town's land use system works and stays legal, a job sits between state law, local ordinances, planning boards, zoning board of appeals, select boards, and the public. They are the translator, the architect, and risk manager of land use policy. There you go.
You're the closest thing we have to a town planner.
I have a friend who was town planner in Portland. She then went and became a yoga teacher, and she's now a counselor, a psychiatric counselor. That's the journey of the town planner. Yoga, yes, go yoga.
Move to adjourn?
I have one other question. We talked about, upgrading our mapping. And I gave you, Joe, a statement of work, I think we saw it at the last, selectmen meeting, about, things to include. I know that Don was gonna put together a statement of work, but I haven't seen anything on it.
I don't recall you giving me a statement.
I'd like to see it with Bob.
I would like to get some comments from the, planning board. There's a couple of things I know that I didn't put on there that probably should, but, I'll update it and forward it to.
Can you, send it? Could you email it to me?
Yeah.
Or I'll pick it up.
Email it to everybody on the board.
Yeah.
I'd like to get that moving because there's a number of things I think that as you move forward with all these efforts, it would be good if the public could just go online and see.
Yeah, you talked about it, but I think you neglected to give me somewhere we didn't get that.
I've got some thoughts on that.
Yeah, well, I'll send it to you, you can see it, as I said, it's very good example to look at. Borders. It's buried in their website under, assessment. But once you get into it, start looking at how they show the lots on the town map, it's very comprehensive, and a lot of it, what they provide is free. It's just, it's state data that they just overlay.
And there's software, and I found some software where actually the town can buy some software that actually puts all these layers together. I'm not sure how it works.
Yeah, so
it's pretty easy to, pretty easy to drive through it. Go for the layers.
All right.
Renewed motion to adjourn.
All those in favor of adjournment?